You signed it. You didn't read it. And buried in paragraph 14, you agreed to something that could cost you thousands. The average apartment lease is over 4,000 words of dense legal language. Most renters spend less than 5 minutes on it. The landlord's lawyers spent months. Every sentence in that document exists for a reason, and almost none of those reasons are for your benefit. Welcome to Fine Print, where we read the law so you don't have to. Today, the 5 most expensive clauses hiding in your apartment lease, what they actually mean, and the specific moves that protect you. Plus a bonus clause at the end that almost nobody reads until it's too late. Clause number 1, joint and several liability. If you have roommates, this is the most dangerous sentence in your entire lease, and it's usually disguised as boring boilerplate. Here's what it means in plain English. Every tenant on the lease is responsible for the full rent, not their share, all of it. The landlord doesn't see 3 roommates splitting $2,100. The landlord sees 3 separate people who each owe $2,100 until someone pays. Picture this. You and 2 friends sign a lease. 8 months in, one roommate loses their job and quietly moves back home. You might assume the landlord's problem is with them. Legally, it isn't. The landlord can collect the entire missing share from you, this month and every month until the lease ends. And here's the part nobody tells you. The landlord doesn't have to chase the person who left. They're allowed to pick whoever is easiest to collect from. That's usually the responsible tenant still living in the unit, with a steady paycheck and a credit score worth protecting. Usually that's you. Your move, before signing with roommates, put a separate roommate agreement in writing. Who pays what, when it's due, and exactly what happens if someone leaves early. It won't change the landlord's rights, but if a roommate burns you, it gives you a real path to recover your money instead of just an argument. Clause number 2, automatic renewal. Many leases quietly renew themselves unless you give written notice that you're leaving, often 60 or even 90 days before the lease ends. Not when you move out, months before. Miss that window by a single day and the consequences are real. Some leases lock you into another full year. Others roll you onto a month-to-month rate with a premium of $2, $3, even $500 more per month. The lease calls this a holdover rate. You'll call it something else. The worst version of this story happens every moving season. A renter finds a new place, signs the new lease, starts packing, and then learns their old lease already renewed itself weeks ago. Now, they're legally on the hook for 2 apartments at the same time, and neither landlord is obligated to care. Your move, the day you sign any lease, find a notice deadline, and set 2 phone reminders on the spot. One at 120 days before the lease ends, one at 90. And when you give notice, do it in writing, email, or letter, and keep a copy. A phone call you can't prove is a phone call that never happened. Clause number 3, early termination. Life happens. A new job in a new city, a relationship that ends, a rent you can no longer afford. The question is what breaking your lease actually costs, and the answer is buried right here. Some leases name a flat buyout fee, usually 1 or 2 months of rent plus your deposit. That stings, but at least it's a known number you can plan around. That's the good version. The bad version has no buyout at all. It makes you responsible for the rent until the landlord finds a replacement tenant. If the market is slow, or the landlord is in no hurry, you could be paying full rent on an empty apartment for months while living and paying rent somewhere else entirely. Here's good news most renters never hear. In many states, landlords have a legal duty to mitigate damages, meaning they must make reasonable efforts to re-rent your unit instead of letting the bill pile up on you. But this varies by state, so search your state's name plus duty to mitigate before you assume anything. Clause number 4, landlord entry. Your lease decides when your landlord can walk into your home. Read this one carefully, because some leases claim far more access than state law actually allows, and they're counting on you not knowing the difference. Many states require advance notice before non-emergency entry, commonly 24 to 48 hours, and limit entry to reasonable purposes like repairs, inspections, and showings. An emergency, like a burst pipe, is different, but a surprise Tuesday walkthrough is not an emergency. If your lease just says the landlord may enter at any reasonable time, and you sign it without question, you may spend your entire tenancy arguing about what reasonable means with the person who owns your front door. Your move, before signing, ask for the entry clause to spell out your state's notice requirement in writing. It's a 30-second edit. And pay attention to the reaction, because a landlord who refuses to put legal minimums in writing is telling you exactly what kind of landlord they're going to be. Believe them. Clause number 5, the security deposit, and the 3 words that decide whether you ever see it again. Normal wear and tear. Here's the line the law draws in most places. Faded paint, minor scuffs on the walls, carpet worn down in the walkways. That's normal wear and tear, the ordinary aging of an apartment that people actually live in, and it generally cannot be deducted from your deposit. Holes punched in drywall, broken fixtures, burns in a counter, stains that need professional treatment. That's damage, and it can absolutely come out of your deposit. The fight, and there's often a fight, is over which side of that line your apartment lands on. And in that fight, evidence wins. So here's the single best thing you can do, and it costs nothing. The day you move in, before a single box is unpacked, walk every room and film everything. Walls, floors, appliances, inside cabinets. Timestamps on. Email the video to yourself for a dated record. Then do the same walk the day you move out. Deposit disputes are rarely won by the person who argues loudest. They're won by the person holding before and after footage. Many states also put deadlines and penalties on landlords who wrongfully hold deposits. So if yours goes missing, look up your state's deposit return rules before you give up on that money. And your bonus clause, the one almost nobody reads until it's too late. Late fees. The question isn't whether your lease has one. It's how the fee is built. A reasonable late fee is a small flat amount or a modest percentage after a grace period. But some leases stack fees per day. Every day the rent is late with no cap. A rough month can add hundreds on top of rent you already couldn't pay. Many states cap late fees or require grace periods, so aggressive fee schedules aren't always enforceable. But know what's in there before you the test case. So before you sign anything, know that joint and several means all of the rent, not your share. Find the automatic renewal deadline and set reminders today. Price out early termination before you need it. Check the entry clause against your state's law. Film the apartment on day 1. And read the late fee math. Quick note, this is general legal information, not legal advice. Laws vary by state, and your situation is your own. For real decisions, talk to a local attorney or a tenant rights organization in your area. Many offer free help. If this saved you money, subscribe because there's a lot more fine print where that came from. Next time, the gym membership contract and the clause that makes it almost impossible to cancel. The law. Explained.